Recording in progress.
Assuming that the Department of Basic Education is wanting to increase the accessibility of alcohol in schools. We are simply saying that from the experience of our learners and our parent members, as well as research and other health organizations, we feel the likely consequence of this policy will be increased access. Our parent members feel very passionately about this, and they are very excited to come and discuss this issue with the committee when the public hearings commence. Then regarding Honorable Boshoff, your question around the statist ideology and how do we distinguish between the responsibilities of the state versus that of community. I think that I think in general, and this I feel aligns with our constitution. We South Africa's constitution. We strongly believe in the ability of people to determine their own outcomes, the ability of people to have a say in their own lives. However, there are overarching principles of dignity, equality, and fairness that if communities and if individuals are not able to access those in their communities, or if communities who hold power are unwilling to relinquish certain resources or or to stop perpetrating certain oppressive or discriminatory tactics, that it is the duty of the state to get involved. We unfortunately see that such issues occur in basic education, and although ideally this would be a situation that doesn't occur in general and therefore involves no need for the state to be involved, the reality of the situation is this has not been remedied by communities and school governing bodies, and so invariably the state must step in to protect constitutional rights. Thank you. I'll hand over to my colleague.
Thank you very much. So in respect of the first question, which is criminal offences for parents or undocumented learners who provide fake documents, and what is the best solution for when that happens. Okay, so the first thing I suppose to note there is that has, now that undocumented learners are able to access school without having to provide any form of documentation, the incentive to provide fake documentation has obviously lessened to a greater degree. So that's just something to bear in mind. But in respect of the instances in which that still occurs and that something needs to be done, the first principle to keep in mind there is that any form of punishment, any form of punishment that's thought of or is sought to be imposed has to take into account how the child is affected by it. So is the child going to be out of school as a result of the fact that we want to punish the parent for putting together fake documents? Or is the child's parent going to be locked away and then leave them without a parent or a caregiver, which is also undesirable and not in the child's best interests? So any punishment, and we're not necessarily against repercussions or consequences as a result of providing fake documents, but it's just that there needs to be a balance between ensuring that there's an understanding of what the underlying causes are, and that any consequences that happen in relation to the provision of fake documents don't have a punitive effect, are not overly harsh, and don't impact children negatively, since they actually had nothing to do with the offense that was committed. And so that's the real submission there, is just attempting to find a balance that seeks to end the forging and provision of documentation that is fraudulent, while taking into account ensuring that children aren't punished through parents with overly harsh penalties such as prison, or through them being removed from school. Then I think there's also something else that might need to be clarified a little bit, which is that EE and EELC don't have any great opposition to documents being provided at school. Those are, of course, necessary for school administration. They're necessary in order to verify the age of the learner. the necessary in order to identify the identity of the learner, where that's something that's necessary to do. It's just that some of the documents within BELA don't seem to serve that purpose. So to just give you one example, one of the documents that's required in respect of refugee and asylum seeker children is that they, on being admitted to school, must provide their asylum seeker permit, but then within 3 years of being admitted to school, need to provide their refugee permit. And so it's unclear to us what the purpose of what the school needs the refugee permit for, when the only reason, as we understand it, that a school requires these documents is in order to verify the age of the learner and their identity, and through the initial provision of their asylum seeker documentation that is clarified. And then there was a question that asked, what are we doing in respect of documentation? And so I think it's really important to say from the get-go that our first port of call, and I think, EE and Equal Education Law Center and a number of other civil society organizations who share some of the issues that we have with BELA, the first port of call has always been to make sure that children obtain documentation. And so that has been the first strategy that Equal Education Law Center and other organizations have taken. So there's been numerous challenges that have been brought, high-level engagement that has been had with the Department of Home Affairs. Just to give you a few examples of those, there have been there's been a challenge that was taken all the way through from the High Court to the full bench of the High Court to the Constitutional Court in respect of the Births and Deaths Registration Act, which prevented single unmarried fathers from being able to register the birth of their children where the mother is unavailable, absent, deceased. And so single unmarried fathers were the only persons who were able to register those births, but in terms of the act, they were unable to. And so South African fathers and South African children were not able to respectively register the births and receive the birth certificate. So that challenge was actually successful in the Constitutional Court maybe just less than a year ago, and yet it actually still isn't being implemented. And when civil society actors attempt to try to take that judgment to the Department of Home Affairs in order to make sure it's implemented, it's kickback is still received from the Department of Home Affairs in respect of its implementation. And there's been challenges in respect of refugee children who join their parents who are recognized refugees and obtaining derivative status under their parents' files. But as soon as the child arrives at a later stage in South Africa than the parents originally arrived, which is often how flight from the country that the person is at risk at works, the parents will leave first, ensure that they're settled in the country, that they're in their destination country, and then children will follow after that. So when children arrive later, the automatic response often from the Department of Home Affairs has been, well, you never declared them on your application form, or they've arrived later. We're not 100% sure that these are your children. And then children will just become undocumented and require legal intervention, if not court applications, to make sure that they actually do end up being documented. And so I won't go into the whole entire list of ways that we try to make sure that we attempt to get documentation for children as a first port of call, but it's the important thing to say is that that's where the strategy starts. But what became apparent is that because it got so difficult to make sure that children were obtaining documentation, and in the interim they were being prevented access from social services, healthcare, and education, that there needed to be we needed to ensure that there was access to that too. And that is how it ended up that we have a judgment that says that undocumented learners are able to access education, and that we want to continue to protect it and make sure that that's respected through BELA. Thank you very much.
No, okay, thank you very much. Thank you very much for your responses too. We have noted your contributions. I've just checked your website. You've last updated it in 2020. So Let's just get all our houses in order. Your annual statements, I've just checked them now. They've last updated in 2020, but it's fine. I was just asking for my own interest at a personal level. So thank you very much. We are not going to break. We don't have time really for that. So if someone feels that you need to scratch, just scratch, get tea, get whatever. We don't have time. We don't have time. We are moving to the Human Rights Commission. They are online. Thank you very much. Thank you very much.
Good afternoon. Good afternoon, Chair. May I go
All
ahead?
right.
Can you hear me properly?
Yes, you can proceed, Amandre.
Thank you so much. Thank you very much for this opportunity. I am joined, Chairperson, by Kenneth Sitebe, who is my research advisor in my office, and Fadla Adams, the parliamentary liaison officer. I'm Andre Gaum, and I am a commissioner of the South African Human Rights Commission, responsible for the right to education. It is specifically also a privilege for me to join you as a proud former member of the Portfolio Committee when I was a member of Parliament. So the Commission is an independent national human rights institution established in terms of Section 181 of the Constitution to support constitutional democracy. There is you will see our slides there. Thank you very much, Fadla. Under Section 184(1) of the Constitution, the Commission is mandated to A, promote respect for human rights and a culture of human rights, B, promote the protection, development, and attainment of human rights, and C, monitor and assess the observance of human rights in the country. The South African Human Rights Commission Act provides that the Commission must review government policies relating to human rights and may make recommendations. So in August 2022, the Commission convened a roundtable attended by a wide range of stakeholders. In part, the roundtable sought to unpack the proposed provisions relating to admission and language policies, explore the interpretation of the provisions and their potential impact on the education sector. In line with its mandate, the Commission sought to consult key stakeholders so as to make an informed submission to the Portfolio Committee. In general, the Commission welcomes most provisions of the bill, but expresses concerns over selected provisions. These will be discussed in accordance with the specific clauses. As far as Clause 1, the Grade R clause is concerned, the Commission welcomes the inclusion of Grade R in the definition of a basic education. We have often held that teaching and learning ought to start as early as possible to reaffirm the ability to read and write as the foundation upon which all other school-based learning is built. Equally, the Commission cautions that the necessary resources ought to be made available to follow the inclusion of Grade R into mainstream teaching and learning. We therefore propose to add an additional clause to the effect that the head of department must take all reasonable steps to ensure that Grade R education is accessible in public schools for all qualifying learners, and that public schools where Grade R is offered receive the necessary resources to enable the schools to provide adequate Grade R education. The Commission is concerned that with regard to Clause 4, dealing with the admission of learners without documentation, that this provision is inconsistent with the matter of Center for Child Law and others versus Minister of Basic Education and others, Pakamisa judgment, in which the Commission was also involved as a friend of the court. The Commission is concerned that requiring a list of documents from learners and parents will lead to an exclusionary approach among schools and serve as a deterrent for parents bringing their undocumented children to school. School principals and SGBs are often not lawyers and tend to err on the side of caution when it comes to complying with legislation. The long and complicated list of documents required now is likely to cause confusion and exclusion. The Commission is concerned that Clause 4 compounds challenges relating to the provision of documents in schools by, one, creating a general atmosphere of fear amongst migrant learners, two, deterring migrant learners from accessing their rights, and that it also fails to establish firewalls between educational institutions and immigration authorities for the sharing of personal information. We've also listened to the presentation of Equal Education and Equal Education Law Center in this regard, and we align ourselves with what they have said inter alia, that in the Pakamisa judgment, it said very specifically that no documents should indeed be required. And as they also indicated, a lot of the documents cannot be obtained, which also creates a problem. In terms of Clause 10, read with Clause 1, the abolishing of corporal punishment, the Commission has consistently indicated that corporal punishment should be abolished in schools and hostels, and the Commission therefore welcomes this provision. We have held before that corporal punishment is inconsistent with constitutional values. The Commission welcomes the extension of the definition to include additional degrading treatment of learners. However, the Commission does recommend that the definition of corporal punishment be extended to protect all learners and not only children, seeing that many learners in school attain the age of majority during their school years and are deserving of the same protection against corporal punishment and other degrading treatment. So the definition of corporal punishment should be aligned with Clause 10 is our submission. Then with regard to Clauses 4 and 5 dealing with admission and language. Section 29(2) of the Constitution states that everyone has the right to receive education in an official language or languages of their choice in public institutions where that education is reasonably practicable. Research confirms the undeniable benefits of home language education. The Eastern Cape Education Department has shown remarkable results in expanding home language-based education to the end of grade 6, and the Minister has also recently stated a commitment to increase the home language offering. The Commission is therefore supportive of the need to ensure that the right set out in Section 29(2) is realized, and where such a right is already exercised, that the continued exercise of the right is protected. However, the Commission is indeed sensitive to the difficulties faced in reconciling the aspiration of learners to be taught in their home language and or language of choice with the need to ensure the broader societal objectives of multicultural integration, equitable access, and balanced utilization of public resources. While language policies may cause exclusion, the true nature and extent of this potential exclusion has not really been probed by the department. Without scientific proof of the existence, nature, and extent of the mischief per school and district, the rationality of the steps taken to address the alleged mischief comes into question. One would have expected some clear research indicating exactly what the nature and extent of the exclusion is, and then look for the answer to the mischief. The head of department will need to do a multifactorial analysis in respect of every school when considering a school's language or admission policy for approval. While this analysis seemed to offer valuable guidance, so we agree with the factors that are indicated, the relevant heads need to revert to all the schools in their jurisdiction within 60 days to approve or not approve their policies. There are simply too many public schools in South Africa, over 24,000 for heads of department or even district officers to come close to properly considering all their language and admission policies in 60 days. Most schools' language and admission policies will thus become valid by default according to the bill, which might indeed amount to unfair exclusion. Children affected by a change or lack thereof in a school's language or admission policy are at risk of having their best interests undermined without the head of department having sufficient time to consider these impacts, even though this being their best interest is the first consideration to be taken into account when approving or not approving a school policy. The processes of sections 4.5 and 5.7 are therefore, in our view, irrational, as the intended operations are simply impossible to perform within 60 days. The right of children to be taught in a language of their choice, as well as considerations such as government's limited resources, the need to promote equality and equitable education, social integration and transformation, are severely undermined if legislation creates checks and balances that are not possible to implement. In our view, therefore, a more rational alternative to the bill's approach would be to provide schools, for example, every 5 years, reasonable time to consider the factors outlined in the bill, specifically referring to sections 4.5 and 5.7, and then determine its language policy, with the right then to appeal to the head of department by any party who may be negatively affected by the language policy or suggested amendments thereto. And that is then our proposal in that regard. As far as codes of conduct are concerned, clause 7b, it is our belief that the school's code of conduct should not only focus on these specific areas of diversity included in the bill, being cultural beliefs, religious observances, and medical circumstances, in considering its content and approach. It is recommended that the full list of prohibited grounds contained in PEPUDA be included herein. SGBs must be cognizant of ethnic and social origin, gender, as well as several other issues in the adoption of their codes. Clause 7c sets out a process for a learner to obtain an exemption from a school's code of conduct. It is our view, the view of the Commission, that where a learner wishes to express his or her or their cultural, religious, and or other beliefs, such learners should not be subjected to an increased and additional burden, this process in the bill, so as to exercise this constitutionally afforded right. It is therefore the Commission's position that where Section 29 of the Constitution is not infringed, that is the right to education, limited or threatened, learners should be allowed to express themselves freely and within reason, without needing such expression to be subjected to the approval of the SGB. Subjecting only certain learners to an approval process may impose an increased burden and or obligation on them, which may amount to unfair discrimination. Our last comment is on home education, clause 37. We note and welcome this provision. However, we are concerned about the absence of specific provisions that speak to and regulate online and blended learning. The COVID-19 pandemic and challenges in the education sector has led to the creation of an alternative means to teaching and learning, being online schooling. We, for example, see the UCT online school that is making good progress also in terms of making that schooling more affordable and scale it. And that should certainly be seen as part of the solution for the education system going forward. It is therefore important that the Portfolio Committee reflects on this phenomenon, being online and blended learning, and regulate it accordingly in legislation. This may ensure that learners and parents are not taken advantage of, and that new innovative teaching and learning means are encouraged but regulated. Thank you very much.
Thank you very much. That's Human Rights Commission. Members, any comment? Honorable Boshoff.
Thank you, Honorable Chair and Dr. Gong. I just want to know, actually, I already know you are going to answer that you are not in a position to speculate, but I'm nevertheless going to ask you to speculate a little bit. And that is on the question, yeah, you said that the 24,000 schools, all their policies won't have, there won't be time to evaluate everything. Do you think there might be some categories of schools who would be pointed out for investigating their policies? There's a category of schools which doesn't exist in law, but in popular law, it is commonly referred to as Model C schools. Would you maybe speculate that these schools might be singled out for looking at the admission policies, or would there any rational base be for the department to evaluate school policies, maybe randomly just picking some, or what do you expect?
No, Dada.
Thank you.
Thanks. Thank you so much, Chair. I do think that, Chair, for the purposes of the information that obviously comes out of some of these submissions, from the South African Human Rights Commission, there's a statement that says that the nature of the exclusion on language hasn't been probed, and therefore believing that we need facts before providing a blanket approach in answering the access to schooling, or the determination of who makes admissions and language policies for schools. And I think, Chair, it's important for us to kind of maybe get the department to maybe give us this type of information of whether how many single medium schools are actually there across all provinces, broken down to each province, and whether there has been a determination as to what is the occurrence of maybe a language admissions policies used to maybe exclude certain learners, and whether, you know, the proposals that are put on the bill as refuted by the South African Human Rights Commission actually are helpful and are actually based on fact and a widespread issue, or it is quite specific, and therefore maybe take into consideration that when we consider the bill in its entirety. And the second thing is that there's a point that has been raised around clause 37 on home education. And the question that I have to the South African Human Rights Commission is that it says clause 37 is welcome as is. However, there's concerns regarding the absence of the provisions of online and blended learning. I don't know whether I'm understanding it as such from the South African Human Rights Commission that clause 37 on home education, with all the requirements that has been there, that have been put on that particular clause, is supported by the South African Human Rights Commission, inclusive of, you know, parents' homes being invaded for the purposes of ascertaining whether a child goes to school, and whether, you know, that actually is in line with the Constitution. The second thing around that particular clause is that particularly now there's a lacuna or legal lacuna in terms of the provision of or law that is put in place to kind of facilitate the online and blended learning, and whether the South African Human Rights Commission has any specific proposals around what clauses should be included to ensure that we do not leave out the online and blended learning that is come out very strongly, specifically after COVID, where online schools, are utilized either as a form of home education or parents choosing to take their children there. However, there's only just a draft framework that has been put there, but it doesn't find expression in this particular bill. So if there are specific proposals, it would be interesting to hear what they are. But I think the rest of the presentation, Chair, for me was very clear and explicit around ensuring that we protect the rights of all South Africans in terms of the proposals that have been made. Thanks.
Well, thank you very much. From my side, I'm just interested in knowing from your side as the Human Rights Commission, what is your view on the issue of the language proposals? And I'm asking it for interest's sake, because you are representing all of us and our rights as South Africans. And also on the amendment on the Bella bill as they are proposed by the department, do you see them being helpful moving forward, or what is your view? Thank you very much. In the absence of fans, then can I, Dr. Misa, do you have anything to say? I mean, advocate, sorry.
No, Chairperson, not at this point. Thank you very much.
Thank you, Chair. May I attempt to answer?
Yes, you can proceed.
Yes, thank you very much. Yes. Honorable boss of you are quite right. I wouldn't be able to speculate actioned by the heads of department when they come into operation. Obviously, if the facts would show that there's a selective approach of only singling out certain schools in terms of checking their language policies and approving or not approving those policies, then obviously it would be irrational, and that approach would be unconstitutional if that would happen, but I cannot speculate as to how things would pan out. Then, yes, obviously, also in view of our presentations that we made, we would think that it is important for the department to provide the necessary information as to exactly as we put it in our presentation, what the mischief is pertaining to exclusion relating to language, what the extent thereof is, in which schools is this taking place, and all those facts are very important for consideration from the side of the portfolio committee as to what specific intervention then to make, and whether the proposed interventions in the Bella bill would be the adequate answer to that particular mischief. I see, Chair, I see my image is breaking up. Can you still hear me clearly?
Yes, we do hear you.
Okay, maybe I should just put my stop my video if you don't mind. Maybe it will be clearer now. Then, as far as the matters concerning home education is concerned, we do not have specific proposals at this point in time. It is something that we will have to look into if the portfolio committee can also request us to specifically look into that, which we will be happy to do. But there is the need for a regulatory regime to be included in this bill, in our view, on online and blended learning. earlier because to some extent, the schools like the UCT online school and so on are not acting at the moment within the confines of legislation, and therefore there might be questions as to how lawful their activities are. That specific school has also indicated that in some provinces they have problems with the registration, that there is no legislative framework. So that's certainly something to be looked at. As far as the home education provisions are concerned, yes, you know, I take the point that maybe some of these provisions need to be looked in. You called right that is created that for homes to being invaded, as you put it, and so on. So there might be on closer scrutiny constitutional issues pertaining to some of the provisions, but we are generally very much in favor of regulating the schooling in this particular way and making provision for that specifically in the legislation in the South African Schools Act. Then there was the question from the chair pertaining to our view on the issues relating to the language proposals. As we indicate, one of our major concerns here would be the 60 days that is provided to heads of department to actually then assess the language policies provided to them and then to take a decision within such a short period. We believe that it is simply not possible to cover all schools within that 60-day period, which may indeed make the legislation irrational in that respect. And therefore, what we propose is to swing around the process so that negatively affected people can appeal decisions from schools that, for example, every 5 years, schools are provided with the opportunity to taking note or taking into consideration the factors listed in clauses 4 and 5 to then come up with their language policies, and that there is then a right to appeal from the side of negatively affected persons in that regard. So we don't think that the proposals as it is currently contained in the bill are rational in itself and would indeed lead to irrationalities in terms of its execution, because it is simply not possible to execute it within 60 days. And then if I understood your comments or your question in terms of the other provisions in the bill and so on, what we how we see those provisions, the ones that we did not specifically comment on, we are indeed in support of the relevant formulations in the bill. Thank you very much, Chair.
Thank you very much to the Human Rights Commission. And thank you very much, Andre, for the presentation. We are noting the issues that you have raised as a Human Rights Commission. And so we move. Thank you very much. Thank you very much, Andre. We are now moving to
much, and all best.
Okay. The Western Cape Commissioner for Children. This is the last one before break. Then we're gonna break. After them. Thank you. You can proceed.
Good afternoon. That is the most unenviable position to be in the way of somebody's lunch. Chairperson, why do you do this to us? I am now an enemy immediately. Well, hopefully we're going to create a nice vibe in the parliamentary chamber because you will hear more from children than you will hear from me this afternoon. My name is Christina Nomdu. I'm the Western Cape Commissioner for Children. I was appointed on the 1st of June 2020. You know, South Africa should really be proud. We are only the second child rights ombudsperson in the continent of Africa. The only other ombudsperson is in Mauritius. We have visited them, and I can say that I'm also very proud that the democratic culture in South Africa makes it possible for all humans to have rights. And now here comes the big contention that we put on the table. Children are humans too. So we want to create with this institution the possibility for children to participate in the governance of their country, to participate in decisions that affect their lives. We sit here with the Basic Education Laws Amendment Bill, and the category of person most affected by this is the child. And we only have with us here, and maybe I don't know on the screen, but with us here in the chamber, only one child. John Lee, he has that unenviable task now of being the representative in person. But as I say to you, you will hear many other children's voices during this presentation. Our written presentation is very comprehensive, and so I just want to create an opportunity for the children to converse with you about their viewpoints, where they come from, and you know, they are forward-thinking, our children. They belong to the next generations to come. So we must try to listen with that kind of you know, acceptance that the world is changing. And if we listen to them carefully, if we bring like the generations together, we will be able to see where the world is going to. And also, if children admire you, if you're considered a trustworthy and good role model, they will follow your value system. They will follow your example. So this institution, the Commissioner for Children, should be seen as the bridge between adults and children in the society, but also as the microphone, as one of the children say, the platforms for children's voices to be heard. So we will talk about a few issues only. Children and the Commissioner make recommendations in relation to the parents' role in their child's education, allowing alcohol to be sold on the school property, the principle of non-discrimination, and the understandings of discipline in the school. And those presentations will be made by children and just recent adult. He's just gone into adulthood. So I just want to play for you a voice note from some of the children who understand what our office is about.
There is a special person in our province that must protect children's rights. She is called the Children's Commissioner. She has been given superpowers to do her job to protect all children. Her first superpower is to look for anything in government that stops them from making children's lives better. For example, she wants to understand if schools and clinics are good places for children and how to make them feel safe. Her second superpower is to gather information that helps us understand children better. She wants to know about children's dreams and worries. Her third superpower is to tell everyone how wonderful children are and that they must be valued. She asks adults to listen to children's views and opinions. The Children's Commissioner listens to children, especially when nobody else wants to, so that everyone can do what they need to do to make children's lives better. RX Radio. RX Radio rocks.
RX Radio is a radio station on Red Cross Hospital run by children with disabilities. And so those are the ambassadors that have captured our sentiment for our office. But let me hand over to the man of the moment, the boy of the moment, our only child physical representative in the house, John Lee.
Greetings to everyone present here today. My name is Johnny Plakis. I'm a 15-year-old representative of the Child Government Monitors. Today I'll be speaking about parental roles in children's education because they are the primary duty bearers of children's rights. It is the parents' responsibility to enroll their children into schools and make sure they go to school. The bill proposed that we send parents to jail that did not comply with this responsibility. The Commissioner and the CGMs did not agree with this proposal. There are many things that must be taken into account when children do not attend school. Children and families may be affected by poverty, depression, bullying, and gangsterism, and so much more. A CGM named Matthew said about children not attending school. It could be the trauma they experience at home because of their parents that use drugs and abuse alcohol. Maybe they must support themselves. The WCCC and CGMs recommend parents not to be put in jail if they are not able to ensure their children are attending schools. Parents may need other social support systems as well. Thank you.
Thank you, John Lee. I'm going to hand over to Ambrose.
Good afternoon to our Honorable Chair and our Honorable Members of Parliament, the Children's Commissioner, and everyone that is so beautiful this afternoon. I am Ambrose Phillips, an ex-monitor, as the Commissioner said, and a current mentor in the Commissioner's office who ably assisted the Commissioner in compiling the billable submission. The alcohol consumption on school grounds during events and fundraisers makes it easy for children to access alcohol. John Liplakis, a 15-year-old monitor, expressed his concerns about this when he probed, wouldn't learners be at the dance and get a hold of the alcohol some way or another? Alcohol use and abuse, as well as the consequences thereof, are very well understood by the children. They were vehement in the views that alcohol shouldn't be allowed to be sold on school property. They are afraid this might lead to underage alcohol consumption and abuse, as well as a generational culture of acceptance of alcohol as part of school culture. The CGMs reached a consensus on the fact that alcohol should not under any circumstances be associated with schools. The atmosphere that condones alcohol consumption on schools is a concern. The CGMs recommend that alcohol should not be allowed in any circumstances at schools. Thank you. You may proceed to the next slide.
Vumbai Watamba will tell us about the principle of non-discrimination.
Greetings to my fellow child government monitors, commissioner, and members of parliament. My name is Vumbai Watamba. I am 16 years old and I'll be talking about non-discrimination in schools. Non-discrimination in schools is something we are still fighting for, and one of the biggest issues is language. Language in schools is necessary and should not be used as a factor of discrimination. We, as the child government monitors, believe that all kinds of languages should be catered for, depending on the number of learners speaking that language. Language in schools is very important because, as one monitor said, called Leander, language helps in understanding the work being taught, and you are able to educate yourself, as most of material is in a familiar language. With this being said, the Western Cape Commissioner for Children and the child government monitors disagree with the school governing body setting language policies, but this should be set by the head of department, taking the community demographic into consideration. Language policies should not be used to exclude learners living close to the school. The Western Cape Commissioner for Children and the child government monitors suggest a more detailed orientation when language policies are developed, and that a higher authority sets these policies to prevent discriminatory practices.
We have the next slide, please.
Another issue that is a huge factor of discrimination is gender. Schools do not offer freedom of expression when it comes to gender, which is discriminatory. For example, learners part of the LGBTQI+ need to be comfortable in their chosen identities, but school policies do not allow boys to wear dresses. One monitor called Ruwan also said, yes, they are discriminated against. Children can't help that God created them that way. If they feel they are more comfortable with long hair, this should be allowed. And if they want to wear dresses, then the school must accept this and the communities in which they live in. Children feel that gender and sexuality identity choices that learners make should be respected and not discriminated against. The Western Cape Commissioner for children and the child government monitors agree with school policies, but should be considerate towards diverse gender and sexual identities. We suggest that codes of conduct are more considerate towards the LGBTQI+ identities and allow freedom of expression, reducing discriminatory events. Thank you so much.
Mbai could not be with us because she's actually a matriculant at 16 years old. So we'll hear from Leander all the way from Beaufort West.
My name is Leanda Sokuyega. I am 16 years of age and I am a child government monitor in the Western Cape. I'll be talking about discipline at schools on behalf of the children's government monitors. As monitors, we believe that discipline should be more about providing guidance more than punishment. We fully agree with the South African School Act 84 of 1996 that states that corporal punishment was abolished in schools. We do, however, have cases where children have reported being corporally punished by educators and principal. Tara, who is also a monitor, voiced out that if someone does corporal punishment, they should be fined or sent to prison because school should be a place for children to feel safe and not feel endangered if they do something wrong. We recommend that perpetrators of corporal punishment at schools penalized.
So from these conversations with children, we understand that they have a very good understanding of the value of education. They know of that we need to use this as a way to propel ourselves forward. A monitor said, and I'm going to read in Afrikaans first and then in English so that we say the true words of the children. Kinders wat die skool gelos het, maak asseblief seker dat hulle akademie ontvang, want akademie is die beste wapen. Children who have left school prematurely, please make sure they also get an education because education is the best weapon. So in conclusion, we advocate for child rights respecting schools, and the key issues that we have highlighted are that parents play an important role in their child's education, but they should not be criminalized for their child's lack of attendance. Alcohol abuse negatively affects children and our society, and so it should not be permitted on schools. Schools should actively promote non-discrimination, whether in decision-making or in respecting the rights of LGBTQIA+ learners. Discipline and order are essential for the functioning of schools. Codes of conduct should not be punitive, but should be restorative and supportive. Most importantly, the right of children to be heard must be protected. This infographic was also developed on Canva. I don't know that thing, but the children do, by our 17-year-old matriculant. And so, you know, we have such a wealth of expertise from children on their lived reality. All we need to do is to create the platform for them to talk with us. Thank you very much to the honorable members, the chairperson, the stakeholders, and guests all present, especially my star child here today. Thank you for giving us this platform.
Thank you very much. Those are the children of South Africa. So let us let us engage them as members of parliament. I've noted the principal, Notada, and Bishop in that order.
Chairperson, thank you, and thank you very much. Without these children, there is no principal. Thank you. That's why I want to talk a bit. And after this fascinating exposition which our kids have given to us, I think we have to dearly appreciate the initiative shown today and this very morning. Though I want to start with this unorthodox fashion. Why Mama, do you call them Western Cape? You call yourself Western Cape Commissioner for Children and Child Government Monitors and not South Africa. And I know you see that's where I want to stand. Because to me, it would have more impetus if you see, everything has got its own corner where to start. But that you started in the Western Cape, it doesn't necessarily mean you are going to die Western Cape Commission. You see, that's my first worry. But the approach you brought to us, I believe surely must be considered even by the Bella bill, the bill itself. And because you are making the main stakeholder participate fully on matters that affect them. You are not, you see, I'm not trying to say those who presented before the approach was wrong, but I'm saying one is highly impressed by this approach because the participants themselves are coming to the fore and saying this and this and this is not gonna do us any good in our education system. So it's a direct communication message, not an indirect. You see, when they talk about discipline, they are not saying we should not be disciplined. Listen what they have to say. They say, let discipline serve as guidance and support rather than as punishment. This is their view, and which is a constructive view to assist in our education system. When they go to discrimination, very vocal to indicate that they are not in support of the discrimination, which simply means, and it is addressing quite a number of challenges that we are having, whereby you see when you go to schools, some of which something which the same amendment on the bill is seeking to address, where learners will continue to be discriminated, either because of their language, because of whatsoever, when they are supposed to access education. And they are talking directly onto that. We are not going to be used as objects of discrimination in whatever form. I'm not going to go deeper whereby they talk about alcohol and all the like, but I think, Chairperson, the long and short of what I wanted to say is we have had these kids, and having had these kids as members of the portfolio committee, ours is to go and make the necessary reflections so that we see going forward, when finally this bill is going to be adopted by Parliament, some of and the number of factors that they have they brought forward be taken into consideration for the sake of our future education system, which is actually affecting them directly. Some of us were growing, you'll be dead not long. So they are talking, they are still very young. None of those kids who spoke is above 20 years, very young. As a belief, let us be considerate. Thank you very much, Mama. That's why I clapped hands for that approach of yours. Thank you very much.
Thank you so much for a very lively presentation. Really, really appreciate it. And I think a lot of the sentiments shared that were presented by the children. I just have two questions for you, Commissioner, and the monitors. Because I got this flyer on email and I read through it. And there are two things that are not on here. One of them being the support for the HOD to determine language policies in schools. So my question to you is twofold. As the Western Cape Child Commissioner, have you in any way, with collaboration, either through the current Department of Education, or other stakeholders made a determination as to what is the widespread extent in which, for example, school language policies may be used to exclude particular learners. And whether or not would it suffice if those school language policies were still determined by school governing bodies, considering the point made by one of the monitors that they must look at the demographics of the learners, the language of needs, and the school governing body in determining those policies, having considered that, if those policies still may be used to discriminate in excluding certain learners, then the mechanism still remains that, look, the HOD then must intervene. Would that still suffice? Considering that when I listened to the presentation by the different children, the bone of contention was to say that these policies must not be used to discriminate against any child that is seeking access to education, of which, again, the Constitution protects us with those rights of making sure that we're not discriminated against when accessing education. But the Constitution also protects us to say we can study in the language of our own choice. And where reasonable and practical, and that can be provided. And the Northern Cape, for example, I'm an Afrikaans speaking learner. There are Afrikaans speaking school, and the language policy provides that I can speak my Afrikaans, or I'm in the Eastern Cape, in Umbu somewhere, where the policy of the school can provide me to speak my Xhosa, and I can study in my Xhosa. However, they are also, in determining that, in the same environment, schools that may be dual language, in the same environment in the Northern Cape, where I can choose to go and study in my English, or in the Eastern Cape, I can choose to go study in my Xhosa, or my Afrikaans for that matter. And those policies being determined by the school governing body take into consideration what I think the children have rightfully raised. But where there are issues, then the HOD or the MEC, which is the political head responsible, we may then intervene in those instances. Well, that still suffice in terms of what you propose, rather than saying, look, let the HOD approve all the policies that are there. That's the main question that I have for you. As for the rest of the things, I think they're quite clear, and many sentiments shared on them. Thanks.
Honorable Bosho.
Thank you, Honorable Chair and Commissioner, Children Commissioner. I would just like to start by saying that normally when young people are 17 and 15 and you call them children, they feel a little bit agitated. But as the law says that one is a child until 18, I guess in certain contexts, it will be acceptable to do so. As a high school teacher, I would not venture to start a class with 17-year-olds saying children. And I notice in the new guidelines that I may not start it by saying boys and girls anymore either. So what I would like to ask from the Commissioner is, this was a very lively presentation, as you promised, but did the children in fact scripted it? Because that is very important to me, that one doesn't get to a position where adults script something for children to recite. And then I would believe that one is really advancing somewhere. Of course, education is something in which one departs from a position where you say, we are not all equal. Some are adults and therefore they educate others. But on the other hand, as I think the most important person advocating for that was Paulo Freire, who said that teachers actually also learn from children. It doesn't take away that, I wouldn't like to elaborate because it could take unnecessary time. And then I would just like to know from you your opinion on a question. Is it conceivable in your mind to say that a community is not just a local geographical community, but that the language community could also be spread over a wider geographical area. Let's use any locality. I would use Kimberley just for using some example, to say that maybe we would have a Tswana speaking school, a school preferring that, and the children will be spread all over the area, but the school is maybe located in Galeshewe, and that it would be acceptable for that school to accept Tswana speaking children even from the southern suburbs of Kimberley, although there are others which are nearer, other children who might just live across the street, but they prefer language tuition in English, for example. I would just like to know your opinion on that, and with that I'll stop. Thank you. Thank you, Chair.
Honorable Advance.
No, thank you very much, Honorable Chairperson, and also appreciate the very colorful presentation that was, very energetic from start to finish. You can see that it was presented by young people. Chair, I just want to check with the representative of commissioners for children. They are only based in the Western Cape. But I think you'll take, the recommendations by the principal that maybe you must expand to other provinces. But I'd want to check, how do you operate? If there's a case in school of maybe discrimination or corporal punishment or whatever the case may be, how do you address such issues? Do you even get joy, or do you even get assisted as the commissioners when you do approach, whether it's the department or the district or the schools themselves? And also I would want to get your view on the issue of undocumented learners, as it's being one of the burning issues in this session today. And it is highly happening here in the Western Cape and also Gauteng and Limpopo provinces, where you find most learners that are being, struggling with the documentations to get education in our country. So what is your role, in assisting children that are struggling with such challenges? Thank you very much.
No, thank you very much, Honorable Advance. I also think I must join the crew in welcoming your presentation, which was colorful and playful, as as it comes from our children. One, and I'm saying this in good faith. We are writing examinations now, and the clause 3 of section 4 is saying that there should be compulsory attendance. And our children are here. Are they not supposed to be at school? Or I'm just asking. Right? They are here. Are they not supposed to be at school? Taking note that it's time of scopes. Most teachers now, scopes are given, so that children can move to the next grade. But also, just for interest sake, here in Parliament around June and July, we've got what we called Children's Parliament. Hopefully, obvious, you know about it. You are from around. My interest is, does these children participate on it? as it is meant for them and their ideas, because you can see they are brilliant. They are brilliant children, and you would want that type of children to be active participants in such programs. And then the third question is, Western Cape is having the high prevalence of social skills in the schools. Do you have programs that speaks to that? Do you have programs of young people speaking to other young people about the issues of social ills, the issues of drugs, and so on and so on? Because I think it would make much more sense, you know, when a person of their age speak to them. And lastly, we saw your presentation, but we're asking you to resubmit and be specific on the clause, on each clause. What is it exactly that you think must be amended, or what is it that you reject or you agree with from clause to clause? I think because of we have heard your oral submissions would allow you to be specific on each clause. Thank you very much. And I'm handing over now to Advocate Misa.
Thank you, Chairperson. I want to congratulate the learners on the beautiful presentation. Well done. And these are the youth that we are looking for and envisage to lead our future in South Africa. Thank you very much, Chairperson.
Then let me hand over to you, Commissioner, and your children.
Chair, I will start with the hardest question first. Why is this child not in school? Fundamentally, I believe that education can be achieved in many settings. School is a very important setting. Yes, they should be there most of the time. But sometimes they can learn a little bit more about life and how to be active citizens when they just come to one session of Parliament. He will have his turn now and he will have to wait for a long time. Maybe he will age out before he gets another term to get to Parliament. But we have here his mother, you know, who has given the permission, who has negotiated with the school, who has made sure he won't miss exams. The exams have not started yet. He has all his scopes, and she actually said to me, Commissioner, please, I want to see how my child makes me proud. In a setting of the Parliament, I mean, these things, children don't even think that they can come here. So if we create that message out there, that this is also a place for you, the Children's Parliament with respect, people are not changing laws there. They are having an orientation of how Parliament works, and they are engaging. And even at, for example, the Nelson Mandela Children's Parliament, there is not a critical engagement with decision makers. No laws are being reformed there. No critical debates are being had across the generation there. It's a show and tell. I'm putting my colors on the mast now. Ne? It's a show and tell. We must do better. We must do better by our children. They can't just be part of show and tell. We have in our crew members of the Nelson Mandela Children's Parliament, and what they experience with us just builds on that fervor that they want to be active citizens in this country. They want to build this country. They want to be leaders. Honorable member, I call them children proudly because there's a boy who's 17, he's turning 18 in January, he's crying because he doesn't want to turn 18. I don't want to leave the commissioner's program. He represented us, a boy, 17-year-old Sadiq Daniels from Bonteheuwel, born with cerebral palsy, went to the United Nations on behalf of the child government monitors. So this is the kind of, I think, inspiration we try to give with this institution. You are worthy, you have valuable contributions to make, and people are willing to listen to you. The principle of non-discrimination, I'm going to talk broadly and cover questions in that way. If I don't cover a specific question, I can always do so more clearly. But The principle of non-discrimination is always talked about in our children's group. John Lee will explain to you how we come to the words of the children in the submission, whether it's scripted or not, whether these, when I say Zurislia says, Ruan says, whether I wrote those words or whether they wrote those words. He will tell you the whole process of how they meet with the commissioner and how they go about constructing a submission. And, you know, the conversation that we create between us. But what I've learned from the children, as you say, paraphrase says, is that they are at the coalface of this discrimination, sometimes meted out by the adults that they are supposed to trust the most. Sometimes this discrimination comes from their teacher. You've got a bossy cop. You are ugly. And they are not supported in their school environments to bring out this pain. They feel that the school governance system is not on their side. And so they appeal to a higher power. Don't allow the school to discriminate against us. Don't allow them to say, we can't have this hairstyle. We can't wear this clothing. If we are disciplined, we want to be at school, but we don't want to face pain and discrimination. And so I think you must see the call for the HOD to intervene as this trust that there will be someone that upholds their rights to non-discrimination. And so if we can guarantee that that will happen on SGB level, guarantee, then sure, if we can guarantee human rights for all in our country and that children are not murdered every day, then sure. But for me, they are calling to a higher power because their lived realities in schools is one of pain and sometimes discrimination. So I don't want to maybe talk about, I think you wanted me to say what my concept of community is, whether it's narrow defined geographically, whether it can go across. You know, for me, community meant when I was growing up and as a development worker that you come from township. That's what the word community means. If you don't come from township, then you come from the areas with the trees, you know, but that's what community means for me. You may define community in a different way, and I don't, you know, we create this jargon of a word, but all of us have a different understanding of that word. So we must be careful that when we create definitions in law and the way we write law, we are very clear about what our definition of that word is, because it changes now from English and from Christina's understanding to a legal term. So I'm not going to talk a little bit more about that. That's my orientation around community. I'm going to keep the questions that you asked for last because you will be very pleased with the answer about the South African commissioner. So, so I want to talk about this issue around we've covered the children's parliament. We've covered why the children are not in school. Whether they are children that talk to other children, these children, they communicate with other children. They are the leaders. They are sometimes chosen by the community workshops that we conduct to represent on the Child Government Monitors Forum. And they go back and they are that advocate, that self-advocate for children. We take programs to schools. We go to schools as an institution. I must recognize and acknowledge the staff. The entire staff, I want to ask them, the entire staff of the Commissioner for Children, please stand up. That is the entire staff of the Commissioner for Children in the Western Cape. Cameron Seister is Deputy Director, Head of Investigations. Tessa Goldschmidt is Head of Child Participation. And here is the Commissioner. We are in the field. We are the entire staff. So give us chance to grow, give us chance to build. We will do more. We have the clause by clause, ma'am, in the written submission. We do have, so you will find it there. I want to not miss anything before I give John Lee the chance to say, how does the commissioner talk with children? I had to say to John Lee, and he can bear me out on the secret. Today I am commissioner. He will tell you what I am other days. He will tell you what I am other days. John Lee, please tell us, how did you come to know the commissioner? What do we do? How do we get together? How do we talk to each other? How did we come to this thing that is written? Is this the first time you're seeing it? Did you write your own speech? Please tell us. All of that.
Okay, so basically how I met the commissioner was through an RCL workshop at my school. It was one afternoon they asked all the RCL members to stay behind. We have a workshop. The commissioner and Tessa came in, we were asked some questions, we did a survey, we just had general conversation, and she asked if we would like to join. I didn't join at that moment. I went home, I contacted the commissioner and thanked her for coming to our school, because that was the first time an adult took interest in the liking of children, what we think, how we feel, the problems we're facing in school. So I thanked her. She asked me would I like to join. I said yes. That was the 13th of October of 2021. The way we communicate is through WhatsApp, weekly sessions on a Wednesday at 5 o'clock. Each WhatsApp session has their own purpose and meaning. So there'll be a topic of discussion. Tessa would put questions in the group, the commissioner would put questions in the group, and we answer them. And that's how we communicate with each other. We share our views, our experiences, and just what we feel about it. So what we call the commissioner on a daily basis is Christina or Tina, because she says she wants to make us comfortable with being able to speak to an adult, not to feel that we are intimidated by her, that she has more power than us. She wants to be on the same level as children, to understand us and to communicate with us. So that's why to me, I know the commissioner as Tina, when you guys know her as the Children's Commissioner for the Western Province. The way we went with working with the Bella Bill, we had a Wednesday session where the commissioner and Tessa selected a bunch of questions to ask us about the topics that are in the Bella Bill. We give our direct words, which are quoted in the Bella Bill. You will see like, they will say John Lee 14, the quote, it's the direct words I put onto the WhatsApp group. They don't edit it. It's direct words that are put in there. That's how they construct it. That's how they get our opinions. And that's where you get the focal points of the children. It's by our direct communication with an adult. That was the first time that we actually knew about the Bella Bill, that we heard about it, because it's not made aware to children what this is for, what it stands for. So to just have your name in this, to have a say in this is powerful, because as children, we don't get the opportunity to speak. We don't get our views taken seriously. So to have your direct words in there for people in Parliament to see and take into consideration and to change the future for us was amazing. Thank you.
Okay, here's the good news. You have the power to create a South African Children's Commissioner. You, as parliamentarians. I don't have that power. Before this job, I was the commissioner specializing in children's rights on the National Planning Commission for the President. You know that body, right? And the NDP and so forth. And there I traveled from province to province, getting children's views on the NDP. I even have products that will show you. It's called the Children's NDP. So this is just who Tina is, who Christina is. She wants to hear and listen to the next generation, because they are the ones that's going to pull us into the future. And she wants to influence them, to tell them that we need to work from democratic values, that we need to respect each other, that human rights is a wonderful thing. So in order to do that, she must build a relationship with children. So you need to change the South African Constitution to appoint a children's ombudsman in this country. It is squarely in the hands of the politicians. It's not in my hands. My institution is created from the Constitution of the Western Cape and from Act 2, 2019 in the Western Cape. It would require an amendment of the South African Constitution to create a National Children's Commissioner. I encourage you to do so. Please do.
No, thank you very much, Commissioner. for children. And thank you very much to our children that are here. All the staff, I thought they are children too. They are so young. They are so young.
Can I say something about this young staff? The two there, they're sitting there. They have 6 degrees between them. Both have master's degree. The one that looks the youngest is busy with PhD. These are the future of our country. I am the dinosaur in the office, 50 plus, met baie kranklike lichaam, lots of aches and pains in the body. But our future is here and here. We must build generations of leaders in our country.
No, thank you very much. We have noted the issues that you have raised with us. And thank you very much. Thank you very much. Members, we are breaking for lunch. We are 55 minutes late. I suggest that we have 30 minutes only for lunch. It's 5 to 2 now. We are going to break to have lunch and we are going to resume at 2:30. And immediately we are going to have the Skole Ondersteuningsentrum, which is going to do the presentation. Thank you very much. Siyabonga.
It is as a dedicated stakeholder in education that the Skole Ondersteuningsentrum, in English it's a school support center, I'll just talk about the SOS, that we make this presentation on the Bella Bill. Now, the SOS is an independent non-profit organization, and we aim to promote quality education through comprehensive assistance to schools in Afrikaans. Now, we have 1,200 schools registered to our subject societies. We provide training to more than 16,000 teachers every year, and 37,000 learners use our online learning platform, the Skole, with CAPS-aligned content. We also do extensive research on education matters, best practices internationally, but also on the education landscape in South Africa and ITC matters in education. So we do a lot of research, and we also help poor schools and communities in the Western Cape and Northern Cape mostly. Now, the SOS is part of the Solidarity Movement. It's a federation of community organizations based on the principle of self-help. We support and represent, together with other organizations, the Afrikaans-speaking education community. Now, I'm Melanie Buys. I'm Head of Development at the SOS, and I'd like to introduce Mr. Leon Fourie. He's CEO of the SOS, to make this presentation and to convey the broad concerns that the SOS has regarding the proposed Bella Bill. The detail of our presentation is available on our website at skole.co.za, but we also have some printed copies if you'd like to read about the detail. Now, we trust that our input will be received in the spirit of constructive engagement to improve the bill, but also to improve education at large in our country. Leon Fourie.
Honourable Chair, honourable members of this committee, thank you for the opportunity to make this oral presentation on the Basic Education Amendment Bill. Melanie, thank you for the introduction. As you have heard, we are representing, together with other organizations, the Afrikaans-speaking community. However, the principles that we will be presenting are the same for all language and cultural communities in South Africa. Some of the principles are that we believe that all children in South Africa should have access to quality education. Quality education is the cornerstone of a prosperous South Africa, or a South Africa that will be prosperous in the future. We believe that mother tongue education is in the best interest of every child. Research done by UNESCO shows that children that receive education in their mother tongue perform better than those who don't. It also shows that countries perform better economically when learners receive education in their mother tongue. We believe that cultural diversity of the people of South Africa should be promoted, and that one culture or one language should not be superior to any other. The Constitution, Section 29, Section 30 and 31, is enshrined with the rights to mother tongue education in public institutions, the right to protect the different cultural communities, and to join and maintain cultural and religious and linguistic associations and other organs of civil society. We believe that school communities and school governing bodies are best positioned and must have the ability to make decisions in the best interest of their own communities. Decisions shouldn't be forced onto them by the state. Some of the research that we've done shows that there is an increase in the number of Afrikaans-speaking people. 3% in the last 10 years, 300,000 Afrikaans-speaking people. The race distribution of Afrikaans-speaking people, you can see there is 40% white, 9% black African, 50% brown, and 1% Indian or Asian. So Afrikaans is not merely a white language. Increase the number of the increase in the number of Afrikaans learners, there was an 8% increase in the last 10 years of Afrikaans learners, more or less 150,000 or 100,000, sorry. There was a decrease in the number of Afrikaans public schools. So there's a major concern for us in terms of these schools. As you can see, there's a 16% decrease in the number of Afrikaans public schools from almost 1,300 10 years ago to less than 1,100. More than 200 Afrikaans schools were anglicized in the last 10 years. The percentage of Afrikaans schools, single medium Afrikaans public schools, is only 5% of all the schools in South Africa. Our biggest concerns with the Bella Bill is the centralization of state power. With the Bella, there's a definite move towards the centralization of state power in violation of the purpose of the South African Schools Act. During apartheid, there were state schools where the state had full control over the schools. Bella is trying to go back to that model. Public schools are not state schools. They're public schools, which provides control to communities and school governing bodies. With the white paper 1 and 2 of 1995 and 1996, respectively, they reflect the policy considerations for the drafting and promulgation of SASSA. A few very important basic points of departure are listed there. Parents have the most at stake in the education of their children, and they require school governing bodies that can carry legal accountability. Very important. The state needs to provide a facilitating role. Facilities, educators, operational costs to some extent, but with a minimum legal accountability. And it should be based on a participative management. The decision-making powers of governing bodies should reflect their capacity and responsibility to render effective service. And SASSA contemplates a partnership between the major stakeholders, which is the state, the parents, the educators, and the learners. So the move towards greater state power, which is evident in section 5 and 6 of Bella, and with a centralized placement system, is a clear violation of the purpose, the original purpose of SASSA, and not in the spirit of the Constitution. With regards to section 6, if you look at section 6, 13, and 19 of Bella, it uses words like direct, decide, and inform to direct a public school to adopt more than one language, to consider and decide and inform the governing body of the outcome of the appeal. Here, the MEC has full control to decide and make instructions. These words are undemocratic and autocratic. This will enable individuals to strong-arm schools, in our case, Afrikaans schools, to adopt more than one language. The Bella Bill provides no protection for indigenous languages or for, in this case, Afrikaans. English is a more dominant language, although English is not the largest language in South Africa. But what we've seen in most cases, English prevail when placed in competition or in the same environment as an indigenous language. From our experience, speaking with headmasters and school governing bodies heads, Afrikaans schools are under constant pressure to anglicize. Once these schools are anglicized, they don't experience the same pressure to take in any other indigenous language. A while ago, there was a public statement made by 20 organizations representing 600,000 Afrikaans households. These organizations signed a joint statement that says Bella, in its current form, is a breach of the 1994 settlement. I have copies available if you'd like a copy. It states, together with other statements, that a promise was made that language and culture would be protected in the new dispensation. This would include tolerance and space for the preservation and development of Afrikaans and other indigenous languages, that there's a misrepresentation that Afrikaans education is a barrier to access to education in the country, that the constitutional instruments to create room for Afrikaans and other indigenous languages to continue, the new dispensation is now used to undo Afrikaans education. It states that this breach of trust will be irreparable and permanent. So you can see from this statement, it is clear how serious the Afrikaans language and cultural community is about this matter. Our proposal is to withdraw the current version of Bella. It is to give the role of school governing bodies as community representatives should be strengthened to determine the school's policy and make decisions, which is in the best interest of the learners and the community which they serve. The school governing bodies are the best positioned to act in the best interest of their own communities, to provide protection and support to all language and cultural communities, something that is enshrined in the Constitution, and to delegate power to schools with proven management ability. Public schools must be allowed more powers if they have a proven track record. This will free up resources for government and time for the Department of Basic Education to focus on the improving of dysfunctional schools and their education system. Thank you so much.
Thank you very much. Mr. Fori. Thank you very much. Members, Honorable Nodata Suela and Boshoff, and at once in that order.
Thank you so much, Chair. I think the presentation is pretty straightforward and clear. I just have one question. In fact, let me put it. There's one question with two parts. The first question in part is, there's a proposal that says we need to delegate more powers to school governing bodies and management that have a track record of performing. And where do you think the Bella Bill needs to locate this type of proposal? Because part of what the concerns are is, don't strip away powers from school governing bodies to determine Anglo language admission policies. Rather, in fact, give or delegate more powers to school governing bodies and management that actually has a track record of performance. Is there maybe a written submission where you would want that to be located somewhere in the bill? And then the second part of the question is, are you requesting that the bill in itself, in its current form, be withdrawn in its entirety, or just the specific concerns or areas of concerns per clauses that you have challenges with? So that's basically my question. Thanks, Chair.
Suela.
Thank you, Chairperson. I know that covered me on the question of whether S.O.S. thinks that the Bella Bill should be withdrawn in its entirety, because they never said anything about all the other clauses, except that they spend a lot of time talking about the language issue and the attack on African schools. I want to get a sense, in what way is the bill attacking Afrikaans as a language in Afrikaans schools? I need to get a sense, why there is that perception? Why is that view? Thank you, Chair.
Thank you, Chair. Yeah, actually thought Honorable Aduans is going before me. I would like to know, you gave some graphics on the growth in Afrikaans speakers and in the decline in schools, but do you have any information on the demand for Afrikaans schooling? Because it doesn't follow by itself that a growing number of Afrikaans speaking children, they entitled me to use a word. Normally one shouldn't say children, you should say young people or youth or whatever. But how many children and the parents actually have a demand for Afrikaans education? Thank you, Chair.
I think I'm also covered. We really want you to tell us which clause do you think that it really speaks on the attack of the on the Afrikaans schools, because we would have to speak facts. We would have to be convinced to your submission on this attack on the Afrikaans schools. Where is it coming from? Yeah. Anything from you, Advocate Mesa?
No, Chair, no comment. Thank you.
You can.
Honorable Chair, I'll start and then Leon can add to what I'm saying. So I'll take it from the first question, and I think starting with saying how do we want to have more delegated powers to the SGBs and what must be right in the Bella Bill. Now, looking at SASA as it is, there's already a lot of checks and balances built into the existing schools act that allows a lot for SGBs to know how far they can go. And I think what's very important is a principle. I think it's Lee Lakoka. He was the CEO of one of the big motor industries. He said, I hire good people and then I get out of their way and let them do what they can do. And that's exactly what we say the education department must do. That successful schools that have a proven track record for doing things right, you can step back and leave them and take that energy and money and time and spend it on the nearly 80% dysfunctional or underperforming schools in the country. Because I was listening to the equal education person too. The problem is not access to the Afrikaans schools, it's access to quality education. That's what people are looking for. That's what a parent is looking for, to be sure that my child has a reasonable chance for success. So the 5% Afrikaans schools, existing Afrikaans schools, is in most cases grossly over enrolled already. So that 5% schools is not going to make a difference. But changing the 80% underperforming schools will make a huge difference in access to quality education for all. So I think that's where our focus should be. And stepping back and leave the good schools to go on as long as they do well, and the SGBs to take that responsibility. Okay, and then I think one of your big questions was, how is the attack mainly on Afrikaans schools? And what we experience when we look through the Bella Bill, it's on determining language and admission policy. We experience that quite strongly in Gauteng with the admissions. It's a language policy. If you talk about a single medium school, I think that was one of the questions also earlier today, asking how many single medium schools are there? We only count the few Afrikaans one. We don't look at the English single medium schools, because that is not where the problem is. It's the quality schools, and most of them are Afrikaans, that they say language is promoting or is causing a barrier to entrance. So, and that brings us back to the previous thing that I said. If we have quality schools in all languages, then we have access to successful education for everybody. So that is where our focus should be, and not only on the language issue in the school. Leo?
So in terms of the attack on Afrikaans schools, that is from our experience that we sit with our headmasters and they're constantly under pressure, constantly being in a position that they are given certain rights and certain privileges if they take English classes. But our problem is that from what we've seen is it's about 5 years from where an Afrikaans school is becoming an English school to where it is only an English single medium school at the end. There's 200 cases of that happened in the last 10 years. Every 2 months, basically, there's an Afrikaans school, previously Afrikaans school that's anglicized completely. And then what we say there's an attack on them is that once that school is anglicized or English, there's no motivation to bring in another indigenous language in that school. Then it's what it is. Then it's English single medium. So it only goes one way. In terms of the sections inside the law that you can add, so there's a section that's a private school can become a public school, but there's no reversal of that. There's an opportunity that can maybe be explored, and then other places where the schools can get more rights and more privileges if they have a proven track record. As I've shown, language is not about race. It's a race distribution of all South Africans. I think we've answered all the questions.
About the number of schools, we did a lot of research on the number of schools. What we found is in the last 10 years, there's nearly 120 less public schools in South Africa. That's of all languages, despite everything that was built. And we use the numbers of the education department and the formal publications to do our research. Okay, but there's of the 25,000 schools that we have in the country, there's only 1,092 Afrikaans schools. So that's not going to make a big difference in the problem of access to quality education by changing that schools to be bilingual. Yeah, and what we also found is that with our parallel medium schools that also present Afrikaans teaching, is that Afrikaans learners is in 80% of the 79% of those schools. They are less than 50%, in most cases, even less than 30% of the learners in that school.
She wasn't responded to about the demand for Afrikaans education. We know about the numbers, but do we know about the demand?
Okay, yeah. Principal? Let's just also take this one.
My chair, maybe just one question, though it will be preceded by this. I understand the responses from our fellow colleagues as they were trying to respond to some of the questions. But I'm tempted to raise this question that you see, Chair, my understanding was it should be the thirst of every one of us to try and bring South African together. South Africa, it's a unitary state, and the people and everyone must feel free living in South Africa, regardless of where. You see, Chair, there is one presenter from South Africans on the base in before, which came before. I thought I must reserve this question but now I can see it's perpetuating. Maybe this is something which we need to have a common footing on and understand. They made mention when they were presenting about 1995, 1996, that why should we bring changes unnecessarily all of a sudden? Education is dynamic by nature. We cannot be static, and being dynamic, and so is this country. That as we move forward, we must move towards convergence rather than continue to diverge. That should be the purpose at each and everyone's heart. The 1995-96, before the adoption of the Constitution of the Republic of South Africa, every one of us must understand what actually happened during the sunset clause when it has to be done. You see, we cannot live in the past if we aim to build this country into a unitary state. The sunset clause had a number of compromises, including even on education, people in the offices, even politically. All parties were brought together. But now, growing forward, we cannot continue to discriminate each other unnecessarily based on issues like language. And because it is very clear, all what we are seeing here, the purpose of the amendment of, as stated in this bill, it is saying, South Africans, we have worked together for more than 27 years. And we believe it is about time that at the end of the day, the center must hold. The situation whereby SGBs keep on taking HODs, MECs, and the minister to court is not building us. It's actually destroying the country and everything that we are trying to fight for. Maybe the question I should be asking is, given what is being presented, whereby the powers should remain with the SGBs, is this in a way having any way of bringing us together as South African, or is it continuing to polarize us? I'm saying so because, Chairperson, the center is failing to hold because of these powers given to SGBs, which SGB, each and every SGB will have its own policy, though regulated at a provincial or national level, but at the end of the day, the SGB remain with more powers than the powers of the the HOD and the MECs, even that of the minister. Is this assisting in bringing us together or polarizing us? I just want us, somebody to bring me home by responding to that, because we are saying powers must go and remain with the HOD and MEC, who will be able to regulate the rest in different schools for purposes of us having a unitary South Africa. Thank you very much.
It's fine.
Honourable Chair, can I? Thank you. I'd like to start with, maybe I'll just answer honourable members the first question, and then I'll come to your statement of working together and trying to stay in the past. So what we see with our research is that there's a growing number of Afrikaans learners, or even other language learners, that like to study at Afrikaans schools because of the high quality of education that is provided in the Afrikaans schools. but also in a lot of other schools. So it's not only in Afrikaans schools. So we see a growing number. The schools grow bigger. We have fewer schools, but the schools are a lot bigger. So that's what's happening. So we, especially in Gauteng, we see a lot of, what do they call it? The very big schools. The mega schools, yeah, which is not really a very positive pedagogic principle that we'd like to strive to. We'd like to have community schools everywhere, but that's what happens. And even the most oversubscribed school in South Africa, one of these are Langenhoven High School in Pretoria. It's a high quality school. And all the learners from around the city like to come there, but they are taught in English. And that brings us back to, are we asking to stay where we were in the past, or what are we asking? And I think it's very important to know that we do not identify in terms of race. It's important in South Africa that we identify in terms of culture, because that is what makes us special in this multicultural country. If we just have one language, English, in all the schools, we're losing ourselves. We're losing what is special. What we should strive to is for more mother tongue education, because that was what was discussed in '96 also. That was what all the different communities thought they were going to have. And that was not served by the education government by providing more mother tongue education. If you look at international principles, mother tongue education is something that we don't even debate about anymore, because you know there's a clear, it's very positive if you have mother tongue education. That's the best kind of education you can wish for. Sorry. Oh, is that the problem? Okay, Leon, maybe you want to add to that?
I agree with Melanie. Our cultures must be celebrated. Our cultural diversity must be promoted. We have the freedom. We must not restrict that, and that is basic principle. That's how we see that. In terms of the schools, yeah, the research that we do is the Afrikaans schools are much 20–30% larger than all the other schools. Now Afrikaans schools are being built. There was 3 built, only 3 in the last 10 years. 500 schools were built. So yeah, that's one of the problems that we have. All right. Thank you, Honorable Chair.
No, I think let's just leave it here. Thank you very much. Thank you very much to yourselves, Mr. Fori and Ms. Pies. Thank you very much. We have said to the other organization that we have met that it's up to you. You can stay if you want to, or you are allowed to leave if you want to. But we have noted as the committee your concerns that you have raised, and they are going to be part of our consolidated report. Now, I think let's move to world changers.
Recording in progress.
My approach is about the delay. The technical staff. Members and chairperson for Portfolio Committee, Patriotic South African. Good afternoon. Okay. Is it better now? Okay, thank you very much. Thank you for giving World Changers candidate an opportunity to come and say no drugs in any form under any circumstance should be allowed at our schools. In calling for the removal of Clause 8, Section 8A of the Bella Bill, which proposes that the school should sell alcohol for purposes of fundraising and functions. I'm sitting here representing an organization that was conceived 20 years ago after assisting what is now a father of two, a husband, a comrade marathon runner, a television presenter, a businessman, Mr. Kabalo Mabalani. And I would love this committee here to join me in saying no to drugs in celebration of Kabalo Mabalani's 20 years of sobriety. That's a very good example that it can be done, and it's giving us hope that drugs can be eradicated. Early this year, our organization was taken aback when we saw the publishing of the recommendation on the Bella Bill. We thought that shouldn't even have crossed our mind. And our organization over the past 20 years, we've been assisting schools, communities, individuals with issues of drugs and substance abuse. Our programs are highlighted annually on the 26th of June, which is the International Day Against Drug Abuse and Illicit Trafficking. And sadly, this year, as we wake up to commemorate the International Day Against Drug Abuse and Illicit Trafficking, this country, beautiful country of ours, was hit by the death of 21 kids that died at Enyobeni. That was on the 26th of June. That's on the day when we are commemorating the International Day Against Drug Abuse and Illicit Trafficking. And we thought, should this bill be allowed and go through? Basically, we're taking Enyobeni Tavern into the schools. So that means we actually going to encounter even more death. We can even think of more possibilities actually if this bill goes through. Can you, and which is a reality in South Africa, can you also start imagining the school governing body, the school principal that are alcoholic, which is a possibility in this country, and taking advantage of this bill, and then throwing fundraising functions at the school almost every weekend. So this will actually be detrimental to what we trying to achieve. So we have already seen with the misunderstanding when the cannabis was legalized, the DACA, where we saw kids now actually officially throwing parties on the 20th of April. They call it the 420. This has been in existence for a while, but it was only acknowledged when the cannabis was legalized. And the misunderstanding of that to most of the kids was that they can do as they wish with the cannabis anywhere and everywhere. So, and that is what is happening now. And then can you imagine what would happen when this bill is passed to say there will be, the schools can actually sell alcohol. I don't know if you're aware that there is a school already in Hammanskraal that is being sponsored by the alcohol company. And the board there in the school says, we know you are thirsty. So looking at where we are going, if this bill is allowed, we definitely just throwing the future of our kids down the drain. As I mentioned that we've been 20 years in this game when we assisted Mr. Kabalo Mabalani. We've been on the road with the late Minister of Education, Kada Asmal, he used to invite our organization during the school effectiveness to come and teach and talk to kids about the danger of drugs and substance abuse. And we continued on that with other MECs because we have a lot of kids that we have assisted that are actually now coming in. It was only now that when Leondale Secondary School video that went viral on the 420, which is the 20th of April, when the video from the Leondale Secondary School that went viral, that the country was only taken aback to realize the scourge or the misunderstanding of what cannabis supposed to be, what is supposed to be used for. And let me also bring it to your attention that after that ordeal, World Changers candidate was invited by the school governing body, the school management, to come and do an intervention at the school. And we did a presentation to the parents, to the school governing body, the school management. And after our presentation, 2 learners asked for assistance with the use of drugs at school. And that's when we really discovered how big the problem was. We assisted the kids that came voluntarily, and with our support program, those kids, they have now started a support group at the school. They're busy recruiting more kids to join the support group and quit the drugs. For our issue is mainly on the clause 8, section 8A, which seek to propose to have the alcohol being sold at school. So it is on those bases that we started a petition, and we would like to thank the South Africans that actually signed the petition in numbers to say no drugs under any circumstances should be allowed at our school premises. I'll stop there and play the video of how we've been progressing on this. Thank you very much.
Not realize is that whether alcohol will not be sold during school hours, it will be easily accessible because it is legal. And that will certainly protect the youth. Let us remember that 1 children died out of 7 and they want to provide their parents with liquor at school events. Availability of alcohol in this country is like opening doors for evil happening. This simply sends a message that because alcohol is legal, it is okay to buy it. That is when parents, communities, and especially the youth should come in. South Africa has already defined suspectful ills by the lack of participation of communities, parents, as well as the government failing us. I would also like to share my disappointment in the youth for glorifying each other on continued substances. We are responsible for strengthening and shaping the foundation of our society. I feel these as young people.
Use the microphone device on the other.
Should be options. Oh no, it's only the speaker. The only way would be to get the speaker from there to plug it in. I don't know. There's no way to connect that projector speaker here.
Okay, no, I think let's get some questions, ne, from what you have presented, because your okay, members, Honorable Principal, Honorable Suela.
Thank you very much. I think, let us say, we appreciate the world changers for coming forward to give and present their vision. And surely I take it, I understood them, but I want to be more convinced that indeed I heard and understood them. I might have heard them without understanding them, but I want to go home with the full conviction that I understood them. You see, when I listened, number one, they are talking about the petition, which is getting support. Number two, their presentation anchors in the main on clause number 8 of the bill, which talks about the selling of alcohol within school premises. Mudlastulo, did I hear them saying they don't necessarily have problems with the bill as amended, but in principle, their worry is on clause number 8. If so, I'm happy and I'm satisfied. Thank you.
No, then thank you very much, Siyabonga, but my issue is just to check with you, Uri. I'm just making an example. Because some of the school where you are coming, when you are coming in a situation of rural areas, where for any type of event, if a person gets married, they would use a school as a venue for that marriage. If there's any type of event in that rural school, the only place that has a big accommodation would be a school. I'm talking of a very deep rural area. So people would arrange with the school to have that wedding on a Saturday, and they would eat and drink there. So in a situation like that, how do you think a situation like that as well changes should be dealt with? Before you respond, anything, Advocate Misa?
No, Chairperson, there's no comment, thank you.
Okay.
Okay, I guess I'll start with the first question. Yes, our issue is all with clause 8, section 8A, and not entirely with other issues in the bill. And that is actually what our petition was all about. Our petition was to say no drugs in any form under any circumstances should be allowed at the premises of our school as the proposal there. So I just wanted to make that clear. I'm not sure if you answered, sir. Okay. And then it will come into your question, Chair, is that, you know, we are more concerned about we are more concerned about the misunderstanding based on the fact that like unintended consequences always outnumbers intended consequences. So the intention would be that there will be a function and this could be used as a fundraising for the school by hiring that as a venue, school as a venue. But when you actually hiring that as a venue as well, you know, we're talking also from an experience whereby even at the school camp, you always find people who hide the alcohol in there. And the people that are also like cleaning and doing all sort of things, you would find that they would, maybe someone would, before even the function, they would even steal alcohol, hide it somewhere where they're thinking after being drunk, then they even forgot where that alcohol is. And on, God forbid, on Monday, when the kids are back at school, somewhere they find one of the people that has hidden some alcohol, and then that becomes a party. And a pity that if we could get this video, it's the same kids that are talking about the experiences within the schools as well. We're working a lot with the communities, we're working a lot with the individuals, we're working a lot with the schools. So when we combine what is really happening now, and maybe if I can just digress from this for a second, just to make a point. What is now happening with the dacha after it was like legalized? So we have found that the drug dealers, they have now put in some potent stuff and then they sell it now rolled. And then these kids, because of they going to school, they actually target areas around the school where they come in quick to buy and quickly to go in there. But what they've put in there is so potent that now they're calling that drug, you kiss, you marry. Just you go one on the one that is rolled, you're automatically addicted. So now when you open that space, what will then happen is the alcohol industry would also come up with other mechanism of doing the having some kind of a promotion at the school in a different way. They could hire a school for the very same purposes to say this weekend, whatever brand has got like a promotion there, they would pay the school for the certain amount because it's part of the fundraising. But the unintended consequences is that they would also be targeting certain principal and SGBs that are vulnerable in terms of that kind of stuff. And that is where this whole thing can easily just get out of hand. So because then they would say the schools are allowed on that. So the intentions are always very good because then we all want to think about a manageable situation. But then there are people who always who are walking around that same manageable situation. And that's where our concern is. And we really thinking this will really cause more damage than good.
Okay. No, thank you very much. Thank you very much to World Changers. We have noted your concern as the committee. Like we've been saying to others, they are going to form part of our whole consolidated report. Now, can we move to oh, okay. We are going to move now to FWT Klerk Foundation because the National School of Governing Bodies, they are still trying to connect. So in the meantime, let's take the FWT Klerk Foundation. They are online. You can proceed, Tyler.
Can everyone hear me?
We can hear you, yes.
Okay, great. Afternoon, Chair. Afternoon, members of the committee, and to my fellow stakeholders. I am Tyler Dallas, and I am the Manager of Constitutional Programs at the F.W. de Klerk Foundation. The F.W. de Klerk Foundation is a non-profit organization dedicated to upholding the Constitution and promoting the values, rights, and principles enshrined in the Constitution. To this end, the right to basic education fits squarely in the Foundation's mandate, and we welcome the opportunity to make submissions on this very important document. The Foundation would like to draw the committee's attention to several areas of concern we identified in the current version of the bill. The extension of power to the heads of department, the impact on mother tongue education, and the required documents' impact on undocumented learners. The first, the conferral of power to the Provincial Education Department to determine the admission and language policies of public schools and overrule school governing bodies in this regard. The interaction between the governing body, consisting of parents and guardians, the school and the department, are a form of ground-level democracy that should be strenuously defended. We submit the bill will discourage public participation as it subverts the partnership model between governing bodies and the department. The Constitutional Court in Welkom and Harmony High School held the importance of cooperative governance cannot be underestimated. Governing bodies play a vital role and function as a beacon of grassroots democracy in ensuring a democratically run school and allowing input from all interested parties. Both domestic law and court rulings hold that school governing bodies are best positioned as parents or guardians of school attendees and members of their local community to ensure democratic school governance and thereby deal with the admission and language policy of a school, among other things. We draw specific reference in our submission to the White Paper on Education and Training in a Democratic South Africa, 1995, and the White Paper on the Organization, Governance and Funding of Schools, 1996, which hold that parents or guardians have the primary responsibility for the education of their children. They have the right to be consulted with respect to the form that education should take and to take part in the governance. The parents' right to choose includes choice of the language, cultural, or religious basis of the child's education. Public school governance is part of the country's new structure of democratic governance. It expressly states governing bodies will have substantial decision-making powers. This is again emphasized in that the decision-making authority of schools in the public sector would be shared among parents, teachers, the community, both government and civil society, and the learners in ways that would support the core values of democracy. We also draw attention to the potential erosion of mother tongue language education, specifically with reference to Afrikaans schools situated in multilingual school districts. Section 5 of the bill requires the head of department consider the language needs of the broader community in the education district in which the public school is situated when approving a language policy, but it does not make any distinction between language groups. This infringes the right of every person to choose the language of tuition as contained in Section 29(2) of the Constitution. Although in principle, a laudable goal to move to dual medium education, the language transformation processes followed by public universities in South Africa have evidence that the more dominant language tends to take over, as is the case with English and Afrikaans. Research has also shown that education in the mother tongue, especially in the first few years of schooling, is a key factor for quality learning as it improves learning outcomes and academic performance. The UN Educational, Scientific and Cultural Organization, UNESCO, holds mother tongue language is crucial, especially in primary school, to avoid knowledge gaps and increase the speed of learning and comprehension. Of course, no child should be denied basic education on the basis of their religion, culture, or language, and a degree of flexibility must be afforded in any admission policy to allow reasonable accommodation of children who, for example, live within the district of the school or are unable to attend another school due to overcrowding. However, we submit that the school governing body are best placed to make such determination, and thus the admission and language policy should be left with this body, with the parent able to take such decision on review to the head of department in accordance with the partnership model envisaged. The final concern we would like to raise is the potential prejudicial impact on undocumented learners by the insertion of required documents into the Schools Act. In the Pakamisa case, the High Court confirmed that undocumented learners must not be denied access to basic education because of their status. The amendment envisaged to Section 3 of the Schools Act would see a parent of an undocumented learner liable to 12 months imprisonment for failure to produce the required documents. This fails to consider or resolve the practical barriers in obtaining such documents from the Department of Home Affairs. We also submit that the sanction meant to serve as a deterrent to parents who intentionally interrupt school attendance fails to consider the underlying reasons children don't attend school, which includes unemployment, poverty, and lack of transport. We respectfully propose the following amendments to the bill. The deletion of the provisions which take away or limit powers correctly vested with the school governing body and confer them instead to the state. Specifically, these are sections 4 and 5 of the bill, which seek to amend section 5 and 6 of the Schools Act. We believe provincial departments are already overburdened and under-resourced, and therefore not appropriately placed to be the central decision-making power when it comes to the governance and administrative needs of public schools, which includes language policies, admission, staff appointments, and leasing of facilities. Secondly, we propose the addition of a provision dealing expressly with provincial oversight and consultation with the school governing body on language and admission in line with the Constitution and provincial law, with the final decision lying with the school governing body and a reasonable dispute resolution process to the head of department and thereafter the courts. We also suggest a review of Section 1 required documents definition, considering the Pakamisa judgments and existing requirements set in the Schools Act to ensure that the documents serve a legitimate purpose with regard to school administration or admission, and that they are readily accessible and available via the Department of Home Affairs. Lastly, we suggest focusing resources on the implementation of the Use of Official Languages Act to promote mother tongue language education instead of making mandatory dual medium education in all public schools, as this is feasibly not possible given the limited resources of the department and therefore would lead to an erosion of language rights in South Africa. I thank you for the opportunity to present, and I close for any questions.
Thank you very much, Tyler. Any questions, members? Nishap? Tyler, you are alluding to the undocumented learners that they must be denied access to basic education because of their status. Which other countries, in terms of best practice, admit learners with no documentation to their school? If you would be able to allude to that.
I would sorry.
Just before you respond, Advocate Misa.
Chairperson, no, I have no comments, Chairperson. The comments are similar to what we've heard today. Thank you.
Okay. You can proceed, Tyler.
Thank you. In terms of best practice with other countries, I would respectfully ask for some time to furnish that detail to you. The concern that we raised is just based on the changes that would happen to the Schools Act. So the fact that these required documents were not alluded to in the Schools Act as such, but now that they would be amended through the Bella Bill.
No, thanks very much. Thank you very much, Tyler. Thank you very much. We must probably thank you for presenting to us and say that we have noted your presentation as the FW Klerk Foundation. And of course, we are going to put your issues as part of our report moving forward. Thank you very much.
Thank you.
I don't know what do we do now. SGP still has not connected. A guidance from you. We are only left with them. Huh? Let's just wait for Llewellyn is calling. Mr. Matakanya, are you in now? Matakanya. He is connecting. What is happening now? Mr. Matakanya, are you in now? No, I think it's got connection networks. Maybe we must skip him. When? No, I think honorable members, let us call it a day. We are going to, we've got a program next week and again, another 9 presenters. So if we do find time, we'll allow him, but that will be at the later stage or that other week. So for today, because of his connectivity problems, maybe let's call it a day, and then we are going to resume next week. Next week, Tuesday, the 15th of November. I must just emphasize again to everybody that is online that next week we might not be on hybrid. 80% possibility of us not being on hybrid. We will have to be here, all of us, because like we have said, this committee room that we are using is used by the Committee on the Public Protector. So there is no other room that accommodates hybrid. So we are going to proceed on the 15th, 9 o'clock sharp with other, is he in now?
Comrade.
Are you in, Mr. Matakan? Lumka kwavalwa intawo. No, I think let us close. We are going to meet next week Tuesday. Thank you very much. The meeting is adjourned.
So I'm not, yeah, but yeah. It's about Bella Bill. Yeah, it's about Bella Bill. Yeah, so we're gonna have a problem on connection. I just I supposed to have flew to Lokozane to Cape Town. So as poor depend sometimes. So yes. So I was